Hi, everyone. Nice to see everyone, not really, but welcome to our webinar. Marissa Mastroianni and I are very glad to welcome you. People are still coming in, so I guess I'll wait a minute before we start, because I see participants joining. Just give us a few minutes. I'm watching the numbers click up. Okay, so thank you all for joining us. We thought that it's been a while since we've had a webinar on employment-related COVID issues. A few things have been changing now where we feel like we're in a different stage. So we thought it would be a great idea to get you all together and give you a little bit of a legal update. Just so you know where we're going, we have about an hour together. We'd like to present our formal, excuse me, program for about 45 minutes, allow time for questions, and cover, as you can see from our title and agenda, a few different areas. Obviously, COVID and return to work and vaccines and all that is top of mind for everybody. We also want to talk about the new guidance, wellness programs. We're going to speak about the vaccine policies. It seems like the number one question we're getting now is, what should those look like? Should they be mandatory? Should they be voluntary? How are we going to implement them? And then, of course, we're getting a lot of questions about travel as we move into the warmer weather, and people are asking about vacations and whatnot. So we will address that as well. Obviously, in New Jersey, it's now legal, and there's some open issues about that and what this means for the workplace, drug testing programs and whatnot. So we'll address those too. Obviously, we're going to look at federal law, New Jersey law, but also New York law, as we are in the tri-state area. And some of you out there we know are New Jersey based. A lot of you have operations in both states. So we're going to provide guidance on both of those areas. You will hear today from myself and Marissa Mastroianni. We'll go back and forth. And of course, as we go through, please feel free to put your questions in the chat box. We will do our best to get to them. If we don't get to them in a timely manner, we'll get to them at the end. And then, of course, if there's anything more involved, we welcome you to reach out to us after the seminar at any time. We're happy to speak to you and hear your questions. So the first thing Marissa, if you could move to the next slide. Thank you. Okay, so the first thing we're going to go through are vaccination policies. And the number one question, like I said before, is mandatory versus non-mandatory. When we say non-mandatory, we say generally encouraging vaccines. Marissa is going to speak about mandatory policies. And if you are, generally speaking, one of the minority of employers that is having a mandatory policy, what do you need to keep in mind? One of the things you want to think about is the timing of those policies. I mean, when are you going to do them? When is someone fully vaccinated? The backdrop to our discussion today is the March 8th guidance from the CDC. We know anyone who's following this, on March 8th, the CDC came out with guidance for a fully vaccinated person. What does that mean? So that means 2 weeks after you get your second Pfizer or Moderna shot, you're considered fully vaccinated by the CDC, and that frees you up socially. Doesn't really affect too much of the workplace because the CDC and OSHA are still saying keep your plastic barriers in place, keep your social distancing, keep all of those things that you've been doing, your masking, all of that should stay in place in the workplace. But we're thinking about that in the background. And then we have March 16th, the CDC came out with guidance on employer vaccination policies. So we'll be going through that as well. education. Even if you're not having a mandatory policy, what are you doing in terms of education to your workforce? What are you telling them about vaccines, safety, efficacy, where to get them, whether they may, have a reaction, what to do, things like that. Again, I want to be clear that the CDC and OSHA have made clear that any policy you have, whether it's encourage or mandate, you still, at the moment, and if you look at the CDC guidance, it says for now. So this could change, all of this could change, but right now it's for now. These programs are going to supplement current protocols. So you shouldn't be, pulling down your plastic barriers. And why is that? It's because we don't have evidence right now that vaccines reduce the transmission. We just don't know yet. We know that if you have a vaccine, you should be better off if you get the virus, but it doesn't mean you can't still, infect others. And against this background, we know that as employers, it's our duty to provide a safe workplace for all of our employees. So that's why we're keeping all of this in mind as we go forward to develop our policies. So I'm going to hand it over to Marissa, who's going to speak about mandatory policies, and then I'll be back to speak about encouraging.
Hi, everyone. It's nice to be speaking with all of you today. I hope you are all and your families are all well. Like Randy said, I'm going to be talking about mandatory vaccination policies first. And the real kind of guidance on this issue comes from the CDC, like Randy said, but also the Equal Employment Opportunity Commission, which is a federal agency charged with overseeing, anti-discrimination laws on the federal basis in the workplace. They issued their own set of guidance back in December. So that hasn't been updated since December. But according to both the EEOC and CDC guidance, you should be following that, anything that's set forth on the website if you are going to enact a mandatory vaccination policy. But before I even get into the meat of what the requirements are, what it would look like, I have to, it's already under challenge. The ability to enact a mandatory vaccination policy has already been challenged in court. So this was very recently, there was a case filed in the District of New Mexico by a detention center employee who's challenging the legality of the countywide law mandating that first responders receive a COVID vaccine. And that employee is challenging it based upon the fact that all of the COVID vaccines, whether it's Pfizer, Moderna, Johnson & Johnson, maybe we'll have AstraZeneca soon, they're all being passed under an emergency use authorization by the FDA. So the emergency use authorization process is due in large part to the fact that these vaccines were developed much more quickly than your typical vaccine. And when a vaccine is falling under an EUA, the emergency use authorization, that means that a person has to be told before they get the vaccine that they have the right to refuse it. So this employee who filed the lawsuit in New Mexico is saying, well, because of this, that means that the county can't enact a policy mandating vaccines. So it's a brand new case. We'll see where it goes. So that being said, given that there's kind of this gray area now, we can't guarantee 100% that a mandatory vaccination policy will be held to be legal. That being said, a bunch of employers, although the minority of employers, but a bunch of employers have already enacted some policies like this or are planning to. Obviously, as the vaccine rollout continues, that'll just make vaccines more widely available. So more employers may start doing this. But that's just a caveat, something to be aware of. I mean, both the EEOC and the CDC guidance suggests that a mandatory policy would be legal. But that being said, both sets of guidance state that the ability to enact a mandatory policy is subject to local law. So again, it's a little unclear. So I want to start there. And oh, I do see a question here in the chat box. That the question is, will the slide deck be emailed after the presentation? And I'm sure we could arrange for that for all participants to get a copy of this. Okay, so like I said, you got to follow all the government guidance if you're going to enact one of these policies. So I think the first question is deciding if you were going to enact a policy like this, who should be administering the vaccine? Are you as an employer going to offer the vaccine on your premises or contract with some third-party vendor to host it off premises? Or are you just going to leave it up to your employees to get their own vaccine appointments? And there are pros and cons to both approaches. The pro, if you're the employer controlling the process, is you're probably going to be able to get your employees vaccinated, maybe not right now, but a little quicker, in the sense of you're hosting a vaccine clinic and hopefully a lot of your employees will show up and get the vaccine. The downside is, though, if you want to host it either yourself or contract with somebody to do it, that can kind of expose you to a lot of different disability related lawsuits. So when someone gets the vaccine, there are a set number of pre-vaccination questions, which would elicit the person's medical history information, potentially the family history of the individual, which all implicate both the Americans with Disabilities Act, which prohibits disability discrimination in the workplace, and also the federal Genetic Information Non-Discrimination Act, which prohibits discriminating employees based on their family genetic history, for example. So if you're an employer who's going to decide to administer the vaccine or host a clinic, you're going to be getting all this information, whether through you or the person you contract with, about someone's disability status, family history, which you may not want. Because at that point, now you're on notice of someone's potential disability or negative family history, genetic history. And that person could now say in a few months from now, wait, I was discriminated against because of my disability, which I disclosed to you in connection with those pre-vaccination questions at the clinic. So a lot of employers, to mitigate legal exposure, are going to avoid administering the vaccine themselves. That being said, the new CDC guidance that Randy was talking about, most of the new information, because a lot of it kind of parrots the EEOC guidance, is based on employers who do want to host vaccine clinics on premises or off premises. It talks about, who you should be contacting in order to set up a clinic like that, making sure you have appropriate medical staff on hand in case someone has an adverse side effect. So there's a lot of stuff that goes into that question. And if you are considering hosting a clinic, I highly suggest you reach out to us, because there could be a lot of issues that arise from that. And then the next question is, okay, I've enacted this policy. Am I allowed to ask for proof of vaccination? And the answer is yes, according to the EEOC guidance. But you also have to be wary of this. You have to be careful about how you message that requirement. So for your mandatory policy, of course, you're going to want to make sure people are abiding by it. So you're going to request proof, but you have to warn employees in certain messaging ways not to disclose medical information. Just provide me with proof of the vaccination. That's it. I don't want any other, information about, why you haven't done it yet, or maybe you were sick and that's why you didn't get it. You could be eliciting all of that information when you ask for proof. So you want to make sure you kind of nip it in the bud, so you're not getting a lot of information again, which could be used against you as an employer in the future. And then finally, if you're enacting a mandatory vaccination policy, you're going to want to know exactly what's the cost going to be to employees, whether it's fully covered under the insurance plan, and if it's not, guidance suggests, and you should, that therefore pay for the cost of the vaccine, because you're requiring your employees to get it as a condition of employment. And also a quick note too about the proof of vaccination. So all of those records should be treated as confidential. You should not, you should make sure you keep it storage in the right way, like a health record would be, and that way it's not just open to the whole office. And I see a question that asking about whether you can require proof of vaccination if you're not mandating the vaccine, and Randi will be covering that. Okay. So if you are going to enact a mandatory vaccination policy, there's required exceptions that you have to also enact, and it's twofold. So you have to allow for disability accommodations and also religious accommodations, and this is non-negotiable. This is a requirement as set forth by the government guidance. So handling the disability accommodation process first. You have to provide people with an exception to your mandatory policy if an employee can't get it because of a disability. And you have to provide an accommodation unless it poses an undue burden upon you as an employer. And, I'll discuss exactly what that means. But so for example, if an employee has a certain medical condition and their doctor says, you should not be getting the COVID vaccine at this point, then you need to engage with that employee and say, okay, we are going to accommodate you because your doctor provided proof of this. You have a doctor's note stating that, you should be accepted from this policy. So you have to engage in the interactive process with this employee, which is essentially just having the discussion and asking for, like I said, documentation of a doctor's note to support that this employee wants to be accepted from the policy. And also just, what is this employee's job description? Like, what do they typically do? How much interaction do they have with the public, with other people in the workplace? How many other people in your workforce are vaccinated? So this is kind of like a risk assessment as to, okay, so what is this risk going to be of having this unvaccinated employee in the office? And you have to really go through with that. And again, you have to directly engage with the employee to find, a good solution. And the guidance does say that you can rely upon CDC and OSHA guidance for accommodations for this unvaccinated employee, which means you require them to wear a face mask. You require them to keep away from people, just like you would for your vaccinated employees too. But perhaps you then maybe say, okay, well, as an accommodation, typically you are public facing, maybe you're a receptionist, for example. We're going to allow you to continue your job duties, but we're going to move your desk so you're not necessarily right in front of the public and interacting with people. There's a lot of different things that go into this and what is an appropriate accommodation, and it's all extremely fact specific. So there's not one bright line rule that we can say would apply to all receptionists, like I just used an example, or to all attorneys, or what have you. And I also want to note that the EEOC has had an increased attention to mental illness, because obviously you have your physical disabilities and your what we kind of all first think of when you say a disability accommodation. But also, mental disabilities exist as well: depression, anxiety. All of these things have been held to be disabilities. So, for example, if you have an employee who has an anxiety disorder, and that employee presents you with a note saying, my doctor says that I shouldn't get the COVID vaccine because it's going to exacerbate my disorder, that's something you have to pay attention to, just as if the employee said, well, I'm pregnant, so therefore my doctor doesn't suggest I get the vaccine at this time. That's the same process that you have to engage with the employee, whether it's, one type of disability or another. And like I said before, you do have to provide an accommodation so long as it's not an undue burden, which under the Americans with Disabilities Act is a significant difficulty or expense. You're going to have a very difficult time meeting this burden, given the CDC and OSHA guidance. We've been having non-vaccinated employees in the workplace this whole time, so it's going to be hard to show. And then also the religious accommodations. So if someone has a sincere belief that is religious in nature, that says that they won't accept vaccines, then you also have an obligation to accommodate that, so long it's not an undue burden. Now, the definition is a lot less stringent under Title VII for the religious accommodations. It's really just a de minimis cost or burden is what the standard you'd have to meet for an undue hardship. But again, I mean, you should still reasonably accommodate people where you can. Note, social and political views are not religion. So that is not protected if someone just is staunchly opposed to receiving the vaccine due to social belief. That's not something you have to accommodate. And you can also ask for documentation to support a religious accommodation. I do warn you though, you're only supposed to do that if you have a objective reason to question whether the employee is telling the truth about their religion. So that's going to be kind of tough to show as well. And other things just to keep a note, if you're mandating vaccines, you can't disclose who's gotten accommodation. You can't retaliate people who receive accommodations. You can't treat vaccinated and non-vaccinated employees differently because there's going to be non-vaccinated employees who are protected, either due to disability or religion, so you have to be careful with that. And the EEOC guidance is clear. If no accommodation exists, then that doesn't necessarily mean you can automatically terminate someone. And some practical considerations, if there's employee relations issues, you may have a very unhappy workforce if you mandate that they receive a COVID vaccine. Wage and hour questions. So, you know, what happens if you're requiring a vaccine? That probably implicates some wage and hour state law that says you have to pay your non-exempt employees for the time spent getting a vaccine. New York recently just passed a law that requires paid COVID-19 vaccination leave. So under that new law, employees are entitled to up to 4 hours of paid time off per injection. So if they're in a 2-dose regimen, that means they could get up to 8 hours of time off under this new law. And there's also liability concerns. So if you're requiring vaccines, you know, you have to be worried if an employee has an adverse, you know, side effect, is that going to implicate your workers' compensation insurance? Also staffing coverage concerns. You know, a lot of people who are getting the vaccine may be down and out for the first day or two after the second dose. So you have to be weary about that. And obviously be flexible and accommodating. If someone doesn't feel good, you shouldn't be forcing them to go into the office. And finally, if you're an employer that has a unionized workforce, you may have to engage directly with the union.
Thanks, Marissa. If you look in the chat in the Q&A, Marissa, there's a couple of questions. If you want to take the top couple.
Sure.
Relate to what I'm about to speak about, but if you want to take the.
Yeah, sounds good. So the one question is so what's the consequence if you have a mandatory policy and it's subsequently held to be illegal? That's a good question. You may be faced with some lawsuits. I guess we'll have to see how that lawsuit shakes out. I mean, that lawsuit that I was talking about from New Mexico is challenging a county mandate, and that's so there may be that may be different. Even if the court says that that's illegal, the court may just make that illegal because it's a public entity, right, that enacted that policy. It may be different for private employers. And another question about private vaccine events. So the question is what do people in New Jersey who can't get the vaccine unless they're 65 or older, have some medical condition? So essentially, right. So right now it would be a little tough to hold a private vaccine event, whether on site or off site, because at least in New Jersey, and I know to a certain extent New York as well, the eligibility requirements are still pretty stringent. So you probably would want to wait to host some sort of event until it's opened up to everyone. I was watching, for example, Governor Murphy yesterday in his daily update, and he said that May 1st is going to be the day that he's going to make it every adult eligible. So you may want to hold off on that for a little while. And I will pass it to Randy.
Okay, thank you. All right, so Marissa did a great job talking about what a mandatory policy will look like. Just so everyone knows, what we're seeing anecdotally, of course, is less mandatory and more encouraging. So we're calling that non-mandatory. So that this slide is basically what it looks like if you're not going to require vaccines, but you want to encourage your staff to get them as much as possible. I want to point out that in my experience, I mean, the EEOC and the CDC, they're saying, you know, a mandatory policy is okay. That's not law, that's guidance. And there have been other situations where courts do not necessarily follow the EEOC. So there may be a good faith defense argument if you enact a mandatory program based on the EEOC, but it's not, we can't say to you, you're 100% in the clear if you do it, as Marissa mentioned. Theoretically, potentially there's, you know, you could have an order directing you to stop your program, and there could potentially be damages. So that's the worst case scenario. We're looking at that. It's called Legaretta, is the New Mexico case. So we're keeping a close eye on that. But I would have to say, my understanding is it's a minority of employers that are hosting mandatory programs, even health providers, nursing homes. They're encouraging, but they're not mandating, most of them. So what is the benefit of encouraging? Well, first of all, you avoid all of that red tape, so to speak, that Marissa talked about. You don't have to worry about all those accommodations. You don't have to pay for time spent. We suggest that you do, because you want to make it as easy as possible for employees who want to get the vaccine to get the vaccine. So you want to have very flexible time off policies. Of course, if you're in New York, now you have no choice. It's 4 hours per shot, so that's up to 8 hours. You want to provide information on scheduling appointments, where in your area, where can they get them? How does it work? I know there are groups that are helping people who maybe don't have as much, like myself, computer savvy on how to work the vaccine system. So as much help as you can get your employees to get an appointment, you want to provide that. You want to provide educational information. So flyers, what is the vaccine about? What are the possible side effects? Whatever you can do, you want to provide that to your staff. This was a question in the chat, and I think that this fourth bullet is addressing it. So even if you don't have a mandatory program, if you want to require people to say, tell us if you've gotten vaccinated, you can do that, okay? If an employee chooses to get vaccinated, you want to be careful on the messaging. So you want to say to your staff, hey, we have a job-related reason for knowing who's been vaccinated and who hasn't. Let's say we have an outbreak in our workforce. We want to know, you know, who that's going to affect or not. Who's going to have to now quarantine? Do we have customer-facing employees who will have to be home for 2 weeks because they didn't get the vaccine and they have to quarantine? When you ask for that proof, you want to be very careful. As Marissa said, you don't want to get more information than you need. So I would say, let's craft something that says, we'd like to know if you've been vaccinated, you know, as it opens up, as the vaccine becomes available, please let us know if you've been vaccinated. If you have not, there will not be any adverse action taken against you. It's voluntary. We would just like to know, and we don't want to know anything else. So you do want to be very careful about how you message that. But yes, the answer is yes, you can ask for vaccination records. Again, it's a medical record. You want to be careful with how you maintain it. It needs to be confidential per the ADA. This last bullet is just an FYI. Nothing really to know yet, but there's a lot of pending legislation that would prohibit the mandatory policy. So we could conceive a scenario where maybe you roll out a mandatory vaccine and then the particular state you're in says no. Another reason that we're kind of encouragement policy is not mandatory policy. So New Jersey, just so you know, the bill is 50986, Assembly Bill 50986, and it would prohibit a vaccine program unless you're in a vulnerable population. So we're a ways away from knowing what those laws, whether they're going to pass and what they're going to look like. So stay tuned. We'll definitely keep you posted if anything passes. Okay, wellness plans. And there is a question about this, which hopefully I will be addressing in this discussion. So what's a wellness plan? So a wellness plan is, the perfect example is the smoking cessation plan. So it's a plan where an employer encourages wellness in various ways. And these wellness programs are governed by the ADA and the Genetic Information, GINA, which Marissa defined before, the Genetic Information Non-Discrimination Act. And the whole thing about a wellness plan is generally it has to be voluntary, and there's lots of regulations and rules that surround what is a wellness program. In this context, the question is, if you have a COVID vaccine program, is it a wellness program? And unfortunately, like a lot of this area that we're talking about today, I don't have an answer because there's no guidance right now. It's kind of in flux. The EEOC proposed a program, proposed guidance earlier this year, and then withdrew it. And so right now, when you see the news and you see Trader Joe's and so the companies that I list there who are encouraging vaccinations with either cash rewards, we're seeing anywhere from $75 to $100. We're seeing PTO, we're seeing gift cards. All of those, it's kind of the Wild West. We don't know exactly what is governing those programs because no one has decided or concluded whether those programs are wellness programs. That being said, you want to make them as encouraging as possible, as voluntary as possible. So the whole thing about a wellness program is it has to be voluntary. Like I voluntarily enter into a smoking cessation program and my employer doesn't penalize me in any way for not doing it. And that's where we get this reference to de minimis at the bottom of the slide. The more de minimis it is, the more voluntary it is. And the idea being that, if you have a $500,000 surcharge on your health insurance, it's not going to be so voluntary. You're going to feel compelled to participate in this program. Again, there's no guidance right now. There was confusion about what's de minimis. So the EEOC withdrew its guidance a few weeks ago. We don't have an answer right now, but I would say to you out there, if you're considering a voluntary program and an incentive of some kind, keep it small. Keep it really small, de minimis, like I said. Previous guidance on de minimis, talks about the cost of a water bottle or a gift card. It's hard to guide you, but if you want to incentivize, I would just keep it on the smaller scale. Marissa, next slide, please. Okay, let me just check the Q&A and see if there's any other questions on vaccinate. Oh, thank you for this anonymous question. So the question is, if you require an unvaccinated employee to wear a mask when vaccinated employees do not have to do so, or you move a desk or keep a barrier, how do you defeat an allegation of discrimination against the unvaccinated person in New York or New Jersey? So that is exactly what we're concerned about. And I want to caution everybody, while you're encouraging vaccines, that's great, education, all the rest of it that we went over. You want to be very careful that you're not creating, either expressly or impliedly, two groups of people, right? We don't want the haves and the have-nots in your workplace. You don't want any unvaccinated person to feel like they are a second-class citizen, okay? And for that reason, we want to be very careful. You do not want to treat the vaccinated with better privileges and let them take off their masks and work in a different place and maybe get access to certain, catered lunches that other non-vaccinated employees do not get. That is a recipe for disaster, and you will open yourself up to discrimination claims. Right now, it shouldn't be an issue because, as we said, the CDC guidance makes very clear that even though people are vaccinated, all of your workplace protocols for now need to stay in place. So just because someone's vaccinated does not mean they come into work and take their mask off. Does not mean they get any special guidance. I would not have your vaccinated people in a certain area, in a fancy conference room where the others do not, okay? That is precisely what we're worried about, okay? Okay, and we're gonna get to return to office. I'll get to that in a minute. So I wanna be clear on the vaccine, non-vaccine. I know, and it's going to be interesting how this rolls out. Of course, this area of law it's kind of, in my career, so interesting because it's rolling out as, we're living it as it's rolling out, right? So we know in Europe, they have, in Israel, a green pass, where people who have a vaccine get access to certain public accommodations, concerts and restaurants and things like that. Maybe if you want to travel one day, you're going to need that green pass. But right now, we don't have that. Sorry. Let me just we don't have that. And so it's easy to say that everyone needs to be treated the same. We want to be very careful in the workplace that you're treating people the same. The whole point of gathering vaccine information is to manage your COVID response. And that's what we want to communicate to people, not that the vaccinated get better treatment. Okay, returning to the office, I don't have a slide on that, but just a word on that. Right now, the guidance is still in place in New Jersey. Let's talk about New Jersey for a moment, and New York, actually, both of them. The guidance remains the same. In New Jersey, it's Executive Order 107, which continues to say that if your employees can work from home remotely, they should continue to do so. That remains in place. Same thing with New York. So people can still go back to work. We've been reopened the whole time. It's not that people haven't been working. It's just that it's the nature of the job. And can you work from home? Can you not work from home? Technically, this is an area that I struggle with because technically Executive Order 107 is still in place and it still says encourage work from home if the job supports it. On the other hand, people are slowly getting vaccinated, which is encouraging people to go back to the office. So my prediction is that we're going to see a change to 107, but we don't have that yet. So we're kind of in this limbo phase, and we'll update you. But I think for now, in terms of reopening, it should be, we're encouraging people to come back if you're comfortable, if you're safe, and keeping a record of those responses, and reminding people all the protocols remain in place. Okay, let me a couple words on travel because the hour goes so fast every time I do this, and I want to be able to have time for cannabis. And Marissa, we know that New York just had an announcement yesterday about cannabis, which is not really a surprise, but I'm sure you'll touch on that. Travel policies. Just a word on travel. I had a lot of questions at the beginning of the year on travel. Can I eliminate travel? The tri-state had a rule that if you were going outside of the contiguous states of Pennsylvania, Delaware, etc., you came back, you had a quarantine, and some employers really struggling with that because a 2-week vacation is really now 4 weeks. So we worked on some travel policies on prohibiting travel. I think that's going to be less of an issue as these travel restrictions are lifted. Right now, we know that in New York, the quarantine restrictions on travel will be lifted next week, April 1st, and New Jersey hasn't followed suit yet, but we think that they might. That's what we understand. So if that's the case, you want to still follow CDC guidance. So if someone travels and comes back, they have the testing requirements, but they don't have, basically you want to go to the CDC and follow whatever their rules are. Right now in New Jersey, March 25th, as we speak, there is still a 10-day quarantine, and then you can lower it to 7 days if the testing is met. But again, stay tuned, that may change. So I don't think necessarily you need to have a travel that says no travel anymore. If you are one of those employers, maybe, an essential employer that cannot have people out, be very careful that your no travel policy does not discriminate based on location. In other words, you don't want to have a no South American travel policy. That's going to invite a discrimination claim, a disparate impact claim, excuse me, based on national origin. So you want to be very careful. We also want to remind you that if you have New York operations, New York, it's much harder to have a no travel policy because New York has an off-duty legal conduct law. Basically says you can't discriminate against someone for anything that they do off-duty that's legal. New Jersey does not. So give us a call if you have any questions on travel, but we think that that's probably going to be less of an issue as we move forward and kind of reopen a little bit more. Okay, cannabis. I'm going to hand it back to Marissa, who's going to bring us up to speed on the cannabis laws.
Hi again, everyone. I know we still have some questions in the chat, so hopefully we'll be able to get to those once I'm done speaking about this last topic. But okay, so New Jersey has legalized adult use cannabis. And like Randy mentioned, it was announced yesterday that Cuomo and the New York legislature have come up with some sort of unofficial agreement on what legalizing adult use cannabis is going to look like in New York. So New York is probably, this isn't shocking, but New York's probably going to be dealing with a similar type of law pretty soon. This is all relevant, though. It's relevant to obviously New Jersey employers, this new New Jersey laws, but also New York employers as well. And I'll explain that in a little while. But the new laws that were passed by Governor Murphy on February 22nd, there's 3 of them. Some of them have employment protections that all New Jersey employers, again, potentially New York employers, have to be aware of as well. So you have those 3 laws, the New Jersey Cannabis Regulatory Enforcement Assistance and Marketplace Modernization Act. It's a mouthful. You have the decriminalization law and then the cleanup bill. And also Murphy filled the Cannabis Regulatory Commission, which is a 5-member body that is charged with governing both the adult use and the medical cannabis marketplace in New Jersey. That was filled on February 25th. So we are on our way to seeing adult use market in New Jersey soon. Based on our estimates, probably the earliest we'll actually see an adult use market being open in New Jersey is the end of this year, maybe probably more likely the beginning of 2022, but time will tell. So like I said, these laws have some employment protections provided to employees. So first and foremost, and also, I mean, a lot of states have legalized adult use cannabis. So the difference with New Jersey is that the employment protections in this law go much further than other states. So this is incredibly employee protective. So everyone, all New Jersey employers should be looking at their drug and alcohol policies, which I'll touch on in a second. And also, if you are conducting drug testing, there are requirements as well, which I will discuss. But first and foremost, New Jersey employers may not make any hiring decision or take any adverse action, i.e. termination, demotion, what have you, based solely upon someone's cannabis use. So that means that you have to find some level of misconduct before you can really discipline someone who is a cannabis user in New Jersey. So for example, you're a drug testing employer, an employee's drug test comes back positive. You're not going to be able to really act upon that. Generally, there's a few exceptions, but you're not going to be able to act upon that unless there's something else that the employee did wrong. For example, that employee also was found to have cannabis on the work site, which you prohibit. Therefore, okay, there's some level of misconduct there. Now you can discipline them, and that could mean lots of different things. You could issue a written warning, you could suspend them, you could terminate them. There is some other thing wrong here that the employee did beyond just using cannabis. The problem is that, and a lot of times, it's like, oh, well, someone I think is under the influence of cannabis during working hours, and that's prohibited. Well, it's going to be hard for employers, and I'll get to the drug testing in a second, but there's no widely accepted and proven drug test out there that measures real-time cannabis intoxication. So you may have difficulty in proving that someone's actually using cannabis or under the influence of cannabis during working hours. So another protection, and this is under the decriminalization law, employers cannot require applicants to disclose any arrest or conviction records related to cannabis offenses. So you should also check your, review your background check, your applications, make sure you're not asking for that information. And so because of the fact that you really can't take any adverse action based solely upon cannabis use, unless the rules and regulations change, which I'll discuss in a second, it's going to be it might not be worth an employer's time to test applicants for cannabis use, because an applicant, of course, hasn't even started working for you yet. So there's really going to be it's going to be difficult to have some level of misconduct there that's applicable. So a lot of employers in New Jersey are choosing no longer to test applicants for cannabis use because of this law. And the new law in New Jersey places very stringent drug testing requirements. First, the law sets forth 7 specific reasons that you can drug test employees, which include applicants. But again, I just kind of gave you a caveat on that. You could also test people based on an incident that happened that may have been influenced by cannabis, etc. So you want to make sure that your drug testing program is following those specifically laid out circumstances that are allowed, you're allowed to drug test people. But also, and this is the big thing, the drug test has to be based on scientifically reliable, objective testing methods. So fine, that's normal, right? But then we get to, and it must include a physical examination. And this is where New Jersey is much more protective than other states, because now not only at a testing site, so you're probably sending your employees to get urinalysis, for example, there has to be some sort of physical examination happening. And that physical examination has to be conducted by what's called a workplace impairment recognition expert. So these people are certified by the New Jersey Cannabis Commission. And so these people have to go through training and a certification process and all that stuff, which is hard right now because the commission was just formed and there's no process yet. So it's very hard for employers to abide by this law because we're in this gray area where we're not sure what that certification process looks like. No one has been certified as one of these wire, experts. So we'll have to see, what comes down with that. And also to note on that, there is a pending law or pending a bill in the New Jersey Senate that would get rid of this requirement for the workplace impairment recognition expert. There is actually a lot of support for the bill, but obviously it's just a bill. So this may change if it does get passed. But if you are drug testing people for cannabis, you definitely have to review your drug testing procedures because of this new law. And the problem is too, so like I said, we're kind of in this gray area. The employment protections, when Murphy signed everything, the law became effective immediately. However, the employment protections are not enforceable under the text of the law until the commission adopts rules and regulations. Now, the commission has 180 days from the date of signature, so February 22nd, to pass these rules and regs. So right now, the employment protections are not enforceable, but does that mean that you don't want to abide by them during this kind of gray area? The conservative approach would be to abide by the law as closely as you possibly can. So if you are a drug testing employer, for example, and you get an employee that tests positive for cannabis, reach out to us. We're going to want to discuss the pros and cons of how to handle that situation. And also all of these employment protections I was talking about, they only apply to the adult use market. So the medical cannabis has been legal in New Jersey for years, but all of the employment protections for medical users are governed by a different state law, which is pretty similar in most ways to this. So it's not like it's two different standards to apply, but that's just something to note. What also makes New Jersey very special in the adult use law with the employment protections is that there's no safety sensitive job exception. So a lot of other states have said, well, if you have a construction employer, for example, you don't have to have these protections applied to your construction workers who are working on job sites, who are operating machines. There's an exception for those because there's an idea that, well, that person may harm themselves, may harm others if they are under the influence of cannabis. New Jersey does not have any exception for this right now. So all of these protections also apply to those types of employees. Again, that pending bill that I discussed a second ago addresses this issue and would create carve-outs for certain types of employers. So we'll see if that passes. We'll obviously keep you up to date. But I know a lot of our construction clients are asking about this. This is a very hot topic. Also healthcare workers, for example, so stay tuned. There is a federal contractor exception for these employment protections. So if you're an employer with federal contracts, or you have employees that have to pass, for example, the Department of Transportation drug testing rules and regulations, you have drivers that have commercial driver's licenses, those people can be accepted because they would fall under this federal exception. And so, like I mentioned, the New Jersey law also implicates New York employers. So Randy already mentioned New York has an off-duty conduct law that, so New York employers can't take adverse actions against employees who due to their, legal off-duty conduct. So if you have a New York employee, for example, that travels into New Jersey over the weekend, not during working hours or anything like that, completely social, they go to New Jersey, they use cannabis legally in New Jersey, there is a very good argument that under the New York's off-duty conduct law that you cannot take adverse action against that employee who may later test positive for cannabis use. So if you're a New York employer, also reach out to us if you have an employee who tests positive for cannabis use. You may want to discuss, okay, well, why exactly was that, and how to go about going through that process. Now, all of this being said, obviously this is a lot of pro-employee information, but the law is clear that employers can still maintain drug and alcohol-free workplace policies. So you could still prohibit the use, the consumption, the mere possession, sale, anything to do with cannabis in your workplace, on your work sites. And you can also obviously prohibit employees from being under the influence of cannabis during working hours, whether that's on-site or off-site. And that is the overview of all of the new cannabis regulations. And stay tuned, I'm sure we'll have an update for you soon when the rules and regulations come out.
Marissa, terrific. Thank you so much. So let me try to make sure we address the questions, and then I have a couple of cleanup items to just kind of remind everybody of. One of the questions is going back to the vaccines. When asking for proof, do you ask simply for a yes or no via email, or you ask for a copy? I would ask for a copy of the card. We don't just take employees' word, not that anyone would be dishonest, but if you're going to need records. So I would ask for a copy of the card. Vaccine status. Can we ask for a vaccine status proof from our employees so we know what is going on? I think we addressed that already. You can, with all the caveats we already discussed. Okay, some of these other questions I think we did address. Marissa, do you see the couple of cannabis questions? Do you want to touch those and then hit it back to me for the
Yeah, sure. So there's one question about, what can you do? Can you discipline an employee for cannabis use that occurred prior to the date the law went into effect? It's unclear from the text of the law, but the conservative approach would be not to, right? Because that employee could certainly sue you under the, for some sort of discriminatory type claim. You can't discriminate someone because they're a cannabis user. So even having history of cannabis use could fall under that. I mean, the law, obviously, it's brand new, so the law will develop on this issue, but you should certainly discuss with counsel if that's something you may want to do. There's also another question. So if the background check that you conduct on an employee, you get back that they do have a prior conviction for the sale of cannabis or for use of cannabis or whatever, how do you handle that? Well, you have to handle it carefully, right? It can no longer be a a reason why you wouldn't hire someone, for example, based, because that would be based solely on that conviction. So I would actually, though, to even kind of nip this in the bud, you should speak with your background check company or however you do it, if you do it in-house or through the background check, and kind of preempt this and say, I do not want to collect any information about an employee's conviction for any cannabis-related offenses. And that way you're kind of saving yourself some headache, because again, sometimes when you get too much information, that's where you can kind of come into hot water. And the last one is the federal exception for all employees as a federal contractor, or only those working on specific federal projects. So it's for specific federal projects, generally. Again, reach out. We should have a discussion about exactly what type of employees are you saying should be exempted. And, again, this law is going to develop, so we'll see how it shakes out. But the law is clear that that an employer doesn't have to comply with the employment protections if it will show a provable adverse impact on complying with the federal contract. So it obviously then again also depends on what's the federal contract that you're dealing with and what does it say. And I will kick that back to you, Randy.
Thanks, Marissa. Okay, so obviously, I mean, like I said, the hour goes quickly. Marissa and I and our team have been working on these employment issues in real time for over a year now. We're doing our best to keep everyone up to speed, but I just want to remind everyone, if you don't get our blog, please make sure you reach out to us, because that is our #1 way to keep everyone updated on these changes. Sometimes it's weekly. Obviously, we have cannabis now. Stay tuned. As soon as we know more on New York cannabis, we'll let you know. We blogged on the New York COVID leave law, all that good stuff. That's how we keep you up to date. So please let us know if you're not getting them. A quick reminder, in the beginning, last year, we spoke a lot about the FFCRA, the Families First Coronavirus Response Act. That's kind of less and less of that, but I want to remind everyone that the stimulus plan that was passed, I guess, a week ago, the American Rescue Plan, does extend the FFCRA benefits on a voluntary basis through September 30th. It's not getting a lot of press. I know people aren't as focused on it. But again, if you have someone who's out, still we have some daycare issues, the extended family leave, the paid sick leave, and you want to provide paid leave and get the payroll tax credits, that has been extended. First, it was through March 31. Now it's September 30th. We need to keep records. So if you have any questions about that, let us know. There's some other small nuances in the FFCRA that were changed in the rescue plan. So I think that's it. I want to remind everyone how grateful we are that you've, attended, and that we hope everyone is well, and that we're here for you. We're doing our best to help you at least. We don't develop vaccines or anything in the public health, but we're here to help you with your employment questions and, help you deal with your employees and get them back to work and whatnot as smoothly as possible. So our contact information is on the screen. On our website, you can see our bios and our cell phones. We're always reachable. And most importantly, everyone, please stay safe and well. We'll see you next time.
Yes, thank you, everyone.
Bye.